The Supreme Court of Canada said that the door to public interest advocacy has to remain open. Yet, Bill C-49, currently before Senate, seeks to shut that door again. It contains provisions that would prevent public interest advocates to actually advocate on behalf of the public. It would restrict people again to individuals who themselves have been adversely affected by something. First of all, I'm thrilled. I was mentally preparing myself to lose the case. I was not sleeping last night because I was so much getting in the mindset of I'm going to lose this. I was in class with my students when I was reading that I won the case. I held a proper class, lecture, and then at the end of the lecture, I went to the computer to check. I told my students I won the case, and I got a round of applause, actually.
That's all. That's quite awesome. In fact, we were talking yesterday, and then I was surprised that you're not going to check, and you didn't check until the end of class.
My students come first. I have utmost respect to the Supreme Court of Canada, but my students come first.
In the coming days, I'll ask you more in more detail on the judgment. But as a start, one thing that rings my bell when I read the judgment, and when of course when you are arguing or in the Supreme Court, is the question by Justice Mr. Brown, I think. That is the test that could never be met, and we read that in the judgment. When you read that section, what do you think? Or maybe comment on that section of the judgment.
I was thrilled by that because it reduces the problem into something very, very simple and obvious. I do think that in the longer run, the approach taken by the Federal Court of Appeal, which says let's forget about standing, let's focus on the issues, is where I would like to see the law changing. That doesn't mean that every frivolous complaint should be heard, but when there is such an important public interest purpose, when the purpose is not simply to decide with individual cases, but rather with everybody, the issues should be at the forefront, and who is the complainant should be more in the back of seat, so to speak. But that argument of setting a test which can never be met is an impeccable argument. There's no answer to that because it's so true. It also shows how disingenuous the Canadian Transportation Agency's decision was. They pretended to have all this analysis, and the sole basis was really a test which one would never, ever be able to meet.
Yeah, and that's definitely troubling, hearing you say it and reading the Chief Justice wrote in her judgment, for sure. So going to the impact of the ruling on this specific complaint first, and then we'll talk about future complaints. But on this specific complaint, it actually didn't...
I would like to make a step back here, because the question is, what is the impact of this on Canadian passengers? I think that's what we need to talk about.
Okay.
The Supreme Court of Canada said that the door to public interest advocacy has to remain open. Yet, Bill C-49, currently before Senate, seeks to shut that door again. It contains provisions that would prevent public interest advocates to actually advocate on behalf of the public. It would restrict people again to individuals who themselves have been adversely affected by something.
So door opened by the Supreme Court on this case specifically, on that.
The door is open here as a general principle on the existing legislation, and the current government and Minister Garneau puts before Parliament and now before Senate a bill which tries to shut the door again, even though the Supreme Court explained how important public interest advocacy is in this context.
Right, you're right. I mean, they explain how important it is. It's not like they open something that is shut or anything. It is there. They just re-emphasize that, hey, it's public interest standing is important, and yeah, I mean, in this case, it's proof that I'm not going to repeat what you just said. Right.
So in terms of this case, now it is going back to the Canadian Transportation Agency. They will have to do something with it. They may seek further submissions from the parties, they may seek further evidence from the parties, or they may just issue a decision without further consideration. That in and only on a question of how the matter should be dealt with.
I should point out, even the Chief Justice point out, they should go with the game of, I hate to put it this way, but they could go with the public interest standing analysis again route, although not in the way that basically no one can pass, correct?
That's right. They do need to perform an analysis which does not shut the door to everybody. So the real question is, how can you articulate a public interest standing in a manner that strikes a balance? That will be a challenge, and probably other organizations should also be involved in articulating those rules. What I was really perplexed, though, is the minority's ruling. It didn't surprise me. I was expecting Justice Abela, Kakirtanis, and Moldaver to rule against me. I predicted that. What did surprise me is Justice Abela's comments that there was no evidence, which is really difficult to understand because there is actually the airline's policy. The airline gave in writing its policy, setting out how it treats passengers. That is the policy they put into writing, and that is the policy that is being challenged.
Right, but correct me if I'm wrong. The judgment itself by the Chief Justice, the retired Chief Justice, didn't say any much about the evidence itself, right? I mean,
of course not, because that was not the issue. The issue here was standing. The issue was whether I can be a complainant, and the answer is that the agency should not shut the door to public interest advocacy, which makes perfect sense because we are dealing here with very expensive proceedings, very resource-demanding procedures. An average passenger may be able to file a complaint, one-piece paper, but then what? What happens when the airline shows up with a battalion of lawyers? What happens when they take it to the next level, to the Federal Court of Appeal? That it boils down to also the issue of access to justice. The person who pursues the complaint has to pursue it in a way, and it has to be a person who can pursue it through the system. What this case also shows is that I'm a person who is able to see a matter through the whole legal system all the way up to the Supreme Court of Canada. Most people, even if they are personally affected, they don't have the resources to do that. They just don't.
Right, money for one thing, and time, and understanding of the system, right? I mean, I've been trying to follow this case and read this and interview you multiple times. I still get confused sometimes, and I'm not digging deep on the many long lists of Supreme Court cases and lower court cases reference, right? I mean, regular passenger. I mean, what kind of chance would they have going through that kind of complaint?
That's exactly the concern, indeed.
Right, but of course, it's again because this case is not about that, and it's not addressed. Even though you presented in the Supreme Court hearing in last October, but none of that is suggested because it's about standing, public interest.
Yeah,
standing.
It is.
Right. So maybe further follow up on the question on this particular case, which got basically thrown back to the agency, the Canadian Transport Agency. What do you expect in terms of timeline, and can you elaborate on the variation of things that they could do, or like how will you know what they decide?
Sure. In terms of timelines, the Canadian Transportation Agency has 120 days to issue a decision. Although it's arguable that they should do it even sooner because they already have taken up a lot of time while we were waiting for the decision to come out. They didn't stay the process. They just ignored the issue for many years now. So that's one consideration for me to give some thought to. What am I going to ask the Canadian Transportation Agency to do in this situation? The second question is what the decision will be. Canadian Transportation Agency will have to articulate a new text for public interest standing if it chooses to do so. And it should, in light of...
before I forget, what's your view on? Do they have? I mean, I guess you'll be biased making trying to answer this. But is it plausible for them to come up with a different set of public interest standing tests, or that based on your reading of the judgment? I mean, although it's left open, but based on the argument,
it is left open to the agency, and furthermore, they can also choose not to deal with the question of standing and head right with the merit, which is what I would prefer. So that's a question in its own. The agency may say, perhaps after all this mud on its face from the Supreme Court, you know what, we think that there's an important question here, let's deal with that. Let's deal here with the underlying issue.
Right. Which is obviously your preference, right? Let's
go
to the merit of the case and then lose or win on that.
Knowing how much they dislike me at this point, they probably will try to release the issue of standing. I don't want to go into speculation at this point. They could say I have standing, but still the case is without merits. They could say all sorts of things.
They have a lot of discretion. I mean, the court make sure that the discretion is well intact, but they have to be reasonable. And
that's right. And look, in this situation, if they again toss it out based on standing, based on another articulation of standing, which is not reasonable, we are going to take it again to the Federal Court of Appeal. That's why we have appellate courts to correct this until the agency gets its rights.
Okay, so you're not going to give up. If they do something you think is not right or whatever, then you're going to appeal. And if, let's say, if they go on the standing route and something you still feel not right, then you just...
Of course, we'll be back. That's what the Federal Court of Appeal is for. We're going to seek leave to appeal. We're going to take the Federal Court of Appeal, and we are going to fight it again. This type of behavior of ignoring complaints in reality and sweeping them under the rug is not acceptable.
Right. So you're going to wait for the 120 days, or you're going to write them something in the coming days and trying to get a sense of what's going on, not to preempt what you're going to do.
I need to give it some thought. It's a strategic question, and as much as I do think highly publicized on strategy, I don't talk to the media. First I do, then I invite the media.
Okay, all right, understood. So this decision, this Supreme Court decision is never just about one small thing or one area. It's wider implication of things. So in terms of this case, what do you see its impact on your other future work on fighting for Canadian air passengers, or is it kind of superseded or muddled with the government proposed bill of wiping out public interest? Can you comment on that?
I'm concerned that the Bill C-49 seeks to shut the door that the Supreme Court said should be left open. Of course, legislature can change the law, but it should not be changed because it harms the public. So our next big battle will be at the Senate level to ensure that this door remains open.
Right. Okay. So again, this is still the first day of the ruling. Not even 12 hours. What are you going to do? Are you going to celebrate? By the way, I noticed you tweeted, you acknowledged some help that you got. Tell us more about what are you going to do?
First of all, what we're tonight, lots of interviews lined up. Still, I'm just giving interview after interview. This is a very important subject. For a little while, it was actually on the first item on the front page of CBC. Now it's the second topic after Lac-Mégantic. So it is a matter of great public interest because we all understand that the system with respect to air passenger rights is broken and needs to be fixed. And sadly, I'm the only person in Canada who has been working on it for the past 10 years. Fast forward tonight, once we are done with interviews, my spouse and I will be going out for dinner to celebrate. That's a no-brainer. We definitely need to take a little bit of time off. Wow. It has been very stressful. I was not sleeping, and she was not sleeping as a result. I barely got any sleep this last night. I was so stressed. Right. So, tomorrow, business back to usual. We do have the Air Transat saga. We do have students who finally on Monday will get their first assignment in my class. I wasn't even able to hand out the assignment this Friday. I was so absorbed in this that I couldn't really focus myself. So from tomorrow, back to business as usual, work on the cases that are going on helping passengers as usual. On the Facebook group, one project that I would like to look into as the next big development is to involve more people from Quebec, because we don't have a way currently to address the Francophone community. They have a very strong and good culture of consumer activism, consumer protection, and we would like to tap into that. So this will be my next big project for the coming days.
Right. So this may be related to what you were just saying. So online, there are people who actually disagree with the decision and thinking obese passenger, they screw them and they should pay 2 seats and whatever. And of course, there are people who support your work. What do you want to say, the people who are against you or for you?
I would say that it's not against me. They are against this specific issue. I received some emails from people saying that they usually support my work, but on this point they disagree with me. I think passengers need to understand that this is a slippery slope. If we allow airlines to charge a passenger for 2 seats, even though they're on a single passenger, and foresee that the airlines themselves shrink, so it's not the passenger's fault.
Right. I almost forgot that. Yeah. The shrinking seats are too, right? It's not just...
Then what will happen next? Are we going to also allow airlines to put women in the back of the plane or black people in the back of the plane? Being large, and I'm talking about large, not just obese. The media confuses the 2 points. Being large is very much predetermined as much as the color of your eyes.
True.
People don't choose to be large.
Yeah. It's not just, you're right, it's not just obese. Physically, your bone structure and your height and whatnot, you could be large for that seat and especially the seats.
And your metabolism. Some people, they just do differently than other people. Some people can eat as much chocolate as they want and still won't get bigger in girth. They won't gain weight. Other people have to be more careful. So if you have an unfortunate genetic background, plus you are in an environment where you don't have healthy choices available to you for various reasons, economic, income, plus genetic issues, there you have your large passenger.
Right. And
I don't accept the premise that blames people for being large.
Right. It's not just
obese. It makes as much sense as blaming people for being too tall.
Right. And words to people who support you or part of your Facebook group, or
I would like to thank everybody for the wonderful support. The people who have been helping in this court case, specifically Brooke and Gavin McKenzie. They are lawyers from Toronto who helped me pro bono without expecting anything in return, not even publicity. They just one day phoned me and told me, "We would like to help you. Tell us how we can help." So they have been critiquing my legal writing, arguing with me on points like I had been their colleague. It was a very collegial relationship. I was the one writing the briefs. I was the one writing it actually in LaTeX, that's mathematical software for typesetting. But I would send them drafts. They would comment on what I wrote. They would tell me, okay, this word could have back notation, change it this way. They would suggest rephrasings, and Brooke has been absolutely amazing, in particular with her time at very unusual hours. Sometimes we were working at close to midnight, 11 o'clock, and
different time zones.
There is no money that could buy that. Brooke and Gavin McKenzie went well beyond above the call of any duty, anything that money can buy. They put their heart into this case without anything in expectation of return. And I really owe them eternal gratitude for that. Even now when I write legal stuff, legal text, I have in the back of my mind, what Brooke would say about this, how Brooke would correct it. So the learning experience of working with so capable lawyers who have been so generous with their knowledge and expertise has been very humbling, and I'm grateful for that. And for the larger group, of course, there's a different constituency which are close friends, and my spouse, Karen, who has always been through this. And even this morning, she was watching the decision coming out and sending me notes about it as she was analyzing it. helping also with English being my third language. And there's the broader group of people, my students, who have all been very, very patient with me being so excited about something that is not part of the academic curriculum, but of course before and after a lecture, I always talk about this. And it's wonderful to have a class and colleagues at the house who that support you in what you do.
Right.
So I'm grateful for that.
I don't know if you are the only one, but you're definitely one of the very few self-represented litigants that are not a lawyer who won a case in the Supreme Court of Canada. So congratulations, Gabby, and have a great day and enjoy.
Thank you very much for having me. All I can say is I was standing on the shoulders of giants.